Supreme Court was faced with the issue is there a psychotherapist privilege under the federal common law? They went through an analysis to address that. One is they noted that all 50 states had already addressed the issue. There is a privilege under the psychotherapist privilege. Under the federal rules of evidence, what you will see, they made changes in form over the years. And when you look at it, when you go into federal court, they say you may have a privilege under federal common law or state law. They kind of give you that complete umbrella. And so most of the time you don't have the issue. But this particular Jaffe case with the 14 U.S.C. 1983 case, and the police officer who was accused of using excessive force had gone through psychotherapy counseling. So the question became whether there was a psychotherapist privilege. The subsequent cases have addressed, and I think the Supreme Court in this case did a footnote. Yes, in all likelihood it can be waived, but that police officer was the one being sued as the plaintiff's attorney that wanted the psychotherapy notes. A couple things out of the Jaffe case that I thought was important, and it will allow us as practitioners, whether you're defense lawyers or you're plaintiff's lawyers. South Dakota law says there is the doctor-patient relationship instead of privilege, and then there's the psychotherapy privilege. You put your medical or your emotional or your mental state issue, you waive it. That's the presumption. One of the issues that, when I've been going through this over the years and thinking about it, is that I think we don't think hard enough about, at least as to the psychotherapy area, do we automatically waive it? The legislature and the courts probably say we have, and we as lawyers, we have the public policy, the statute says it's a privilege, the statute also says you waive it. But I don't think it's that simple, and for this reason. In the Supreme Court case of Jaffe, when they were analyzing whether they should address the privilege, or there should be a common law privilege under federal law, they noted that treatment by a physician for physical ailments can often proceed successfully on the basis of a physical examination, objective information supplied by the patient, and the results of diagnostic tests. Now, if you have that privilege, you enter into litigation and you put your medical condition in question, you're waiving that privilege. And really, when you look at it in the big scheme of things, what you're doing is you're seeking compensation from somebody else for your damages, for your harm. Well, by waiving that privilege, you're allowing the physician to provide information concerning physical examination, provide information regarding objective information supplied by you as the patient, and the results of diagnostic testing. No big deal. But for effective psychotherapy, the court said, effective psychotherapy, by contrast, depends upon an atmosphere of confidence and trust in which the patient is willing to make a frank and complete disclosure of facts, emotions, memories, and fears. Because of the sensitive nature of the problems for which individuals consult psychotherapists, disclosure of confidential communications made during these counseling sessions may cause embarrassment or disgrace. For this reason, the mere possibility of disclosure may impede development of the confidential relationship. 2 minutes? Well, Brad didn't use all his. Can I use some of his? I'm kidding. We'll get to the heart of it. I think you have to explore more fully before you take the statutory waiver regarding psychotherapist notes or counseling notes under 3632. For this reason. In this particular case, the counselor formed the opinion that disclosure of those psychotherapy notes, which are essentially, in my view, the work product of the counselor, would not only cause embarrassment, but would also potentially cause serious mental and physical harm to the patient. The psychotherapy notes, it's incredible the amount of information that's in there. I've never been able to read them because They're highly confidential, but you're talking about fantasies. You're talking about sexual fantasies among the family members. You're talking about multiple personalities. And it's amazing the stuff, as I'm told, because I haven't read it, that's contained within those notes. And you have to be very, very careful about just saying, okay, we're going to give everything up. Because if you do try to give everything up, you may run into a counselor or a psychotherapist that will prevent you from doing so. Thank you.
Thanks, Bob. Now we'll have out of chute number 5 from Pierce, South Dakota, Bill Van Camp. And Bill's going to talk to us this morning about domicile issues on estate planning.
Thank you, Greg. As is obvious, unlike Bob, I do not get up at 5:30 in the morning and work out. So no matter how wonderful my presentation this morning is, please do not stand at any point. Venue and probate, an exciting topic for 6:46 in the morning. Just as a general overview, I kind of want to run through what the statutes are in South Dakota, and then I'll give you a reason why I think this is an important topic, certainly in my practice, and as I see more of my clients living longer in years and getting married, often a second or third time, coupled with the fact that we're really seeing an explosion of wealth in our farm ranch areas and also in the stock market as a whole. I think you've seen an accumulation of wealth in personal property that over time, as people live longer and move into their retirement years, that wealth concentration really goes. And of course, then we get to the second and third generation who look at that wealth and think, what's in it for me? So I think that when you look at venue for probate, you need to keep in mind that you can only have one venue for a probate. It can not be in more than one jurisdiction in South Dakota, and it cannot be in more than one jurisdiction around the country. Generally, venue is determined where a person is domiciled. Now, in the outline that I gave you, we differentiate between domicile and residence. People often confuse the two, but as the court went through in South Dakota in the Heinemeier case, there is a clear and distinct difference. Residence, as the outline shows, and I'm not going to follow the outline directly, can be as simple as living in a particular location or being in a particular spot at a certain point in time. Whereas domicile really is a state of being or a state of intent. Well, what we get to then is how do we prove that? In Heinemeier, Justice Inner's concurring opinion, which I think is an excellent analysis of the issue, it is living in a location with the intent to make it your fixed and permanent home. Most of us are probably familiar with Heinemeier. It leads into numerous areas of our practice and whether or not we want to sit on a bench in a certain area. But I think that the case law, it is limited throughout the country on domicile, stands for the fact generally that you need to look at a totality of the facts of a decedent, if we're talking about an estate, and where they really did consider their home to be. And oftentimes people will default to a declaration made by that person in an estate planning document, and an attorney will sit a client down and say, where do you live? What's your domicile? They don't even say domicile. Most people don't even use that word. I don't use it in my day-to-day practice. But they'll say, you're in my office, so obviously here to do some estate planning. Is this where you live? Tell me about your life. Well, I live here. Let's go through this process that I might do, 5 times or 10 times a month. And so you gin out your paperwork and you don't consider the repercussions of where this person might have other assets. They might tell you, but you don't go through the intricacies with them. Well, simply making a declaration in an estate planning document, and courts have said this, will be ignored if the facts don't support the declaration itself by the decedent, provided to the client. So simply stating that I'm a resident of South Dakota usually isn't enough if you do get into a case where you have a contested probate based on domicile. Now, I do list in the information some things that case law will support as indications that a court can consider. Voting residents, they do consider the estate planning documents, of course, voting history, insurance disclosure, motor vehicle registrations, tax returns, locations of personal and real property, and relationships, friends, and family where they're at. What I really wanted to talk about and what I've seen is, why does it matter? Well, practically, as we've seen this accumulation of wealth and exponential growth in the value of ag land in South Dakota, what you see is people that have several residences, but of course they can only at the end of the day have one domicile. So what does that matter? What does it probably matter between the husband and wife? What matters is if, in most instances, you have two sets of children who have different beliefs on where the ultimate assets of the husband and wife should be shared or split. And while there are 40 states approximately right now that have a uniform probate codes, those states all vary widely in the application of it as it relates to the spousal share. And what you have, I think as much as anything, in my observation, is an analysis done after somebody's died, not while they're alive, of what the implication is of domicile and the level of specific state on the ultimate distribution of estate assets. As an example, with those 40 states, the augmented state rule in South Dakota, if a spouse dies here, the spouse has a right to elect and take upwards of 50% of the decedent spouse, regardless of what a will says. And in the determination of augmented estate, you include probate and non-probate transfers, which include insurance policies, IRAs, annuities. And you also, in that calculation, include the value of the surviving spouse's assets. You throw it all into a big pot, and then based on the number of years of marriage, you divide it. 15 years in South Dakota gets you 50%. Everybody probably knows that in South Dakota, and you move forward. Now, as I said, there are only 10 states that use some form of the augmented estate, and the percentages are different. In Florida, it's 30%. I think in New Jersey, Pennsylvania, I think I saw it's 33%. So the number changes. We've got a number of states that have elective share rights, but they don't use the augmented estate. They use probate assets. And so a spouse can elect to take a percentage based on the number of years of marriage of what those probate assets are. Well, it doesn't take a lot of planning to do the revocable trust to knock out the probate estate, to basically winnow down the assets that are includable in a share. I even talked about community property, which is completely separate and has its own rules that are unique. So, in my experience, what happens, and this is the practical implication of the issue that I have 10 minutes or less to talk about, is you have clients who have some connection to South Dakota who spend months, and over years those months lengthen in another jurisdiction. If you have any of those people that are in second marriages, you have to be uniquely aware of the issues of domicile, of how to, if they intend for their estate to be probated or their assets to be distributed under South Dakota law, how to keep that domicile located in South Dakota, how to establish that fact beyond the mere recitation of the fact that I'm a resident of South Dakota. Because if they move to another location, it's not the mom and the dad that are going to be fighting, it's going to be the children from the two marriages that are going to be fighting. And the numbers shift dramatically in every state in the union. And it's just something I think in a general practice, we never ask our clients because we're so busy. But at the end of the day, it'll come back and bite you, especially when they move to a jurisdiction where non-probate assets are considered in an augmented estate, or where this elective share is considerably less than it is in South Dakota, and they've got 4,500 acres in Hand County, and now that's a $8 or $9 million estate where before it was only $1 million. So we really need to think about those issues in representing our clients beyond the great state of South Dakota. Thanks.
Thanks, Bill. And please remember, look at this material as it comes on through. You're just giving a snapshot, but really be, at least all these speakers will be available to talk to at any time, either here or later. Now we have Lee Schoenbeck, and Lee's going to talk about the bad faith and the bad faith cases that you see coming through your office.
I interned with Eastland, and we all believed everything Greg said, because he said, well, God may have given the law to Moses, he had Greg carry it down the mountain. There used to be 15 commandments, Greg read. All right, well, you figured that out. Yeah. I'm going to talk to you today
That's better than standing up and clapping. Audio check.
Okay, while they're figuring that out, I'll use my quiet, shy voice. I want to talk to you about insurance. Insurance is critically important in society. You can't take risks, build buildings, pipelines, or buy mortgage homes without insurance. So it's critical for all of us that insurance works, and bad faith is about looking at situations where insurance has worked and punishing those who don't, who allow it to not work properly. I'm not going to, I may not be using any of my, just that. Okay, there, good, thank you. I'm not going to go through the definition of bad faith. You can all read the Ferguson decision that came down 8 days ago and the elements of it. I want to talk about a couple of things to help you understand the insurance relationship, which if you want to look at where our case goes wrong, I think you need to look at, you need to know a little bit about the underlying situation. The insurance triangle is a graphic kind of showed me about the relationships between the different entities in insurance companies. You've got underwriting, you've got sales and claims. And it's important to know those differences because sometimes that will help you understand where the train went off the track. Underwriting assesses the risk. Describes the size of the price of it. Sales sells it. The contract is made here. Claims, services, the contract's all done when claims comes into being, when they get involved in it to service the contract. So, if you see, for example, in a claims file, the involvement of underwriting, something's wrong because underwriting's job is all done. Now we're just trying to service a contract that's already in existence. And so, for example, I had one of these where you find the claims, sends a message back to underwriting and says, if we would have asked them this question and they would have answered this, would we have sold them the policy? And it was a question they didn't ask, that they should have and could have asked, but chose not to when they were deciding a price to it and selling it. And underwriting said, no, if we'd have asked that and we'd have known that, we'd have never sold them the policy. And so that claim says denied. That's called post-claim underwriting. And that's bad faith, and you find a lot of articles about it. But it's important to understand that insurance triangle to get a sense about where these things arise from. I want to talk to you about, I get to give this lecture, some of you have been in it for about an hour or two at the law school every year, so I'm going to condense it in a bunch. When you're looking at bad faith, I think you have anecdotal bad faith, something went bad in that situation, and you can have institutional bad faith, something that's a program or a practice that is bigger than just that situation. I believe that if you look at it, and an opportunity to study how insurance companies measure, that there are very few accidents in insurance company management. They are mathematical institutions. They are studied extensively. Reports are generated. There aren't that many mistakes in math. If you see anecdotal, it means, and you stop there, it means you probably haven't peeled the onion enough to find out what the institutional issues are. And I think after the Bertelsen case that came down 8 days ago, it's going to be increasingly important upon people to take these cases on to look for the institutional issues that underlie the anecdotal issues. I want to try and give you a couple of quick examples. I'm not sure you can all read this. This is from a case that involves a fire. It's a National Farmers Union policy. This is the claims manual. It goes through thousands of pages of these documents when you're trying to peel that onion. This particular one's an ACB policy. We have broad evidence rule in South Dakota. You're looking to see, is there any betterment from the improvements, because you're going to discount for the betterment, okay? This particular policy says, it's right in the claim, not the policy, it's in the claims manual. When they say to depreciate, reduces the betterment, depreciation should be included for tear-off, as this is a function of the betterment. You look at that, if you don't mess around with this stuff much, that doesn't make a lot of sense, it might be kind of boring. Here's what that's telling you. It takes $1,000 to tear down a wall that's burnt. They say, when we removed your burnt wall, we bettered your property, so we're going to depreciate that $1,000, 40% depreciation, we're going to give you $600. You say, wait a minute, I didn't have a burnt wall before that fire happened. And what they're doing in that situation, instead of measuring betterment from before the loss to after the improvement to see if it's better, they take it after the fire and see if they bettered it by the repairs. And that's called stealing. That's an example of a current claims manual used by National Farmers Union all across South Dakota. Here's a nationwide one. Nationwide, remember I took the insurance triangle. The claims people, they don't generate profits. They just service an existing contract. The deal on profit was made by underwriting and by sales. This happens to be a training nodule that they use, and they don't put big red flags on these babies. Thousands of pages of documents. The supervisor trains the claims person, and you can't read that little language. I want to point something. It says here about a definitional page. In that part of it, it tells them about a combined ratio and the formula parts that make up their incentive plan, the definitions. And I just blew up that language out of it. The purpose of this is to teach an overview of the direct impact claims associated handling the claim will have on nationwide financials. Objective, gain understanding of how action by the claims associate directly impacts these financial results. That's not right. And you know why it's not right? How many of you know or would agree that if I'm representing an insured, it's appropriate for me to say to the claims person, I want you to consider the direct financial impact on my client of your decision to deny or pay this claim. And you'd say, that's wrong. The impact on the financial condition of the insured has zero to do with whether an amount is owed under the contract. It is equally wrong for the other side of the equation to tell their claims people, when you're deciding whether to pay this claim, please consider the direct impact your decisions have on the financial results of the company. That's stealing. In fact, the equal consideration rules that are part of the duties the carrier has are clearly violated by that policy. Okay, I want to talk about one more topic before I just briefly touch on the ethics thing, about a minute and a half. In the outline, I talk about first-party versus third-party bad faith claims. I think that's an important distinction to understand, and that issue is muddled by the law in South Dakota. First, I've laid out who the parties are in the outline so you can see it. The problem with the South Dakota case, we have no third-party bad faith in South Dakota. Some states do under their insurance claim practices. We don't. But our court talks in a couple of decisions about third-party bad faith. That's a mistake. It's a first-party claim, a party to the insurance contract, whose claim arose because of initial acts by some third party on the underlying situation. It doesn't change that it remains a first-party contractual relationship with first-party obligations. It It just changes the setting in which some of those arose. And so in the Pine and Bertelson case where they refer to third-party bad faith claims, we don't even have those topics going on. I just want you to, I think if you confuse the terms, you misunderstand the duties that flow from the relationship. And my last thing on ethics, I just, when I saw from the other one, outlined, so now they're outlined as well. You know, you have a duty to be confident, I think, to read the law and understand it, but in more so in the area of bad faith, is to go past that simple little bad fact you saw and do the work to find out what was the institutional issue that allowed that to happen. And not everybody, every insurance company that makes a decision you disagree with is wrong. They're not all bad faith. You have a duty to go further and study the issues more. And thank you very much. I appreciate that.
I wanted to thank everyone for coming out this morning for all of our early bird sessions. Our last speaker today will be Robin Parsons, who will be giving us an update on appellate developments.